We're talking about Ashley Babbitt today, and if you recall, Ashley Babbitt was a woman who was shot and killed by a police officer on January 6th, back during the Capitol Hill protests or riots or insurrection or sedition or whatever you want to characterize it as. And we learned yesterday that the officer who did shoot her is actually not going to be facing charges. And so a lot of people are asking themselves questions about this. That's weird. We're seeing cops all over the country get charged with crimes, or at least investigated and indicted, or going through a more formal process where we're at least asking a grand jury about an indictment. So the example I'm thinking of is the Breonna Taylor case. And Breonna Taylor, right, an officer shot a bunch of bullets through an apartment building, ended up killing Breonna Taylor, shot from the outside, wantonly, recklessly, like a maniac. She's dead. They go through a grand jury indictment proceeding. Grand jury decides not to indict. Well, at least we got a little bit of something there, right? We got an investigation and an attempt to indict. Now, if you look into that indictment process, the whole thing was a sham. We know that. Daniel Cameron over there was sort of manipulating the whole thing, in one man's humble opinion. But the point here is that this officer doesn't sound like he's even going to go through the indictment proceeding. This article comes over from the New York Post. We're talking about Ashley Babbitt. She was killed on January 6th, and the U.S. Capitol police officer who shot her will not face charges. An investigation of the shooting was closed by the Department of Justice on Wednesday. In a news release, DOJ said the unidentified officer, who is still unidentified, we know who the other officers are, right? We knew who Derek Chauvin was right away. We know who Kim Potter is, knew about her right away. This officer, still have no idea who that is. They shot Babbitt with a single shot near the speaker's lobby inside the Capitol, and they're saying that the officer did so in self-defense and to protect members of Congress. Investigators also determined Babbitt's civil rights were not violated in the shooting, according to the statement. We go over to NBC News. They say that no charges were recommended for the officer who shot Ashley Babbitt. Capitol Police said that investigators, quote, used clear, appropriate use of force. It's not even a close call, said the office's lawyer, Mark E. Schammel. And so people are asking themselves questions about that, right? The Department of Justice announced last month that Metro PD of D.C. would investigate the shooting. The officer was placed on leave. This is routine, standard procedure whenever an officer deploys lethal force, says the U.S. Attorney's Office and a Justice Department spokesperson. So we have the press release, and then we're going to go through and take a look at an analysis by a guy named, by somebody named Technofog. And they have a nice Substack little community, and they also have a nice Twitter following. They're also on Telegram. So go take a look at Technofog, not frog, fog. And we're going to go through his analysis because he does a nice job sort of countering this narrative, and we want to give that a little bit of a boost. So let's take a look at the DOJ press release. You're going to see that here. This was released Wednesday, April 14th. It says the Department of Justice closes the investigation into the death of Ashley Babbitt. U.S. Attorney's Office for D.C. and Civil Rights Division of the DOJ will not pursue criminal charges against the officer involved in the fatal shooting of 35-year-old Ashley Babbitt. U.S. attorneys and others, Metro PD Internal Affairs, conducted an investigation. They examined video footage posted on social media, statements from the officer involved and other officers and witnesses to the events. They got physical evidence from the scene, and they conducted an autopsy. Based on the investigation, they determined there is insufficient evidence to support a criminal prosecution. Officials from the IAD informed a representative of Mish Babbitt's family today of this determination. So, quick reminder on Ashley Babbitt. If you recall, this was the woman, they were sort of making their way up the stairwell of the Capitol building. The doors were closed. They were barricaded in. There was one window that looked like it was sort of punched out. And there was a lot of activity in that stairwell, a lot of activity. And so Ashley Babbitt sort of, if I'm remembering this correctly, sort of steps up into the window. So it's sort of a door that has wood on the bottom and a window at the top. The top of the door, the window is blown out. So she was sort of stepping up into the frame of the window to cross through the door, cross through the barricade, and get into, I think it might have been the chamber. So there was an officer on the other side of that barricade. If you watch the videos, tons of videos about this, as soon as she kind of steps up, before she's really through the barrier, you can tell she's going through the barrier. But before you do, boom, an officer kind of just pops out, fires a quick shot. She falls back through the barrier, falls back on the non-breached side, and then is sort of bleeding out there as people are surrounding her. There were other officers in the stairwell also. there was like a SWAT team that was in the stairwell that was just, rendering aid to her right then and there. So a lot of questions about this. Was it excessive force? Was Ashley Babbitt a threat to the officer on the other side? Was she a threat to the people inside the Capitol building? Was this excessive force? Was this excessive force because there were other law enforcement agents on the other side of the door? Like in the videos, you can see them. They're there almost instantly. So were they communicating with one another? Did they need to shoot her? Could one of those other officers have done something? Was this whole situation about to be disposed of? A lot of questions about it. But this officer apparently is not going to be charged according to the DOJ. And a lot of people maybe think that is not such a good thing. Investigation did determine on January 6th that Ms. Babbitt joined a crowd of people that gathered at the U.S. Capitol grounds to protest the results of the 2020 election. Inside the building, Congress convened to count the votes. Members of the crowd outside the building eventually made their way inside. Joint session stopped. Investigation determined that Babbitt was among a mob of people that entered the Capitol building and gained access to a hallway outside the speaker's lobby. This leads to the chamber. At the time, Capitol Police was evacuating people. Officers used furniture to barricade a set of glass doors separating the hallway and the speaker's lobby to try and stop the mob from entering the speaker's lobby and the chamber. 3 officers positioned themselves between the door and the mob. Members of the mob attempted to break through the doors by striking them and breaking the glass with their hands, flagpoles, helmets, and other objects. Eventually, 3 officers positioned outside the doors were forced to evacuate. Members of the mob continued to strike the glass doors. Ms. Babbitt attempted to climb through one of the doors where the glass was broken out. Officer inside the lobby fired 1 round from his service pistol, striking Babbitt in the left shoulder, causing her to fall back from the doorway and onto the floor. U.S. Capitol Police emergency response team, which had begun making its way into the hallway to try to subdue the mob, administered aid to Babbitt. So it was a U.S. Capitol Police officer who shot somebody right as an emergency response team was right there. Why didn't they just let the response team just get there? Because they're on the same police force. Were they talking to one another? Who was transported to the hospital? She succumbed to her injury. She died at the hospital. All right, excuse me. The focus of the criminal investigation was to determine whether federal prosecutors could prove that the officer violated any federal laws, concentrating on U.S. Code 242 under the Federal Criminal Civil Rights Statute. So they're going to do their analysis on why she's not being charged. In order to establish a violation of the statute, prosecutors must prove beyond a reasonable doubt that the officer acted willfully to deprive Ms. Babbitt of a right protected by the Constitution or other law, like to live. Here, the Fourth Amendment right not to be subjected to an unreasonable seizure. Prosecutors would have to prove not only that the officer used force that was constitutionally unreasonable, but that the officer did so willfully, which the Supreme Court has interpreted to mean the officer acted with a bad purpose to disregard the law. As a requirement, this has been interpreted by courts. Evidence that an officer acted out of fear, mistake, panic, misperception, negligence, or even poor judgment cannot establish the high-level intent required. The investigation revealed no evidence to establish beyond a reasonable doubt that the officer violated the law. The investigation revealed no evidence to establish that at the time the officer fired a single shot, that he did not reasonably believe it was necessary to do so in self-defense or in defense of the members of Congress. Acknowledging the tragic loss of life, offering condolences to the family, we have closed the investigation into this matter. So you see what their analysis looks like, right? Willfully deprivation. We've got bad purpose and disregarding the law. So let's take a look. Now, I believe Technofog is another lawyer. He sort of acts in anonymity, so I'm not positive on it, but I'm pretty sure he is. So let's take a quick look at his analysis, because he sort of is saying that the DOJ is full of garbage. Don't have to take my word for it. Let's go to Technofog. We have the DOJ is lying about the Ashley Babbitt case. The force was excessive, so the DOJ punts to willfulness. Today, and this is over at technofog.substack.com, so go check this out. This was public, not behind a paywall, so I'm not jipping his content, so go check him out. Give him some support if you want to get more of his stuff. Today, the U.S. Attorney's Office for D.C. issued a press release explaining their decision not to prosecute the officer who shot and killed an unarmed protester named Ashley Babbitt. DOJ officials, along with Metro PD, they say this was a thorough investigation, included reviewing all the footage and all that stuff. They explained members of the mob continued to strike the glass doors. You'll notice there's no mention, Techno says, of a verbal warning to Miss Babbitt or other efforts to subdue her without the use of deadly force. And you can see that right in this sentence, right? They continued to strike the glass doors. She attempted to climb through the doors where the glass was broken out, so he just shot her. Didn't do anything else, right? Didn't attempt to push her back or tase her or pepper spray her or do anything. And we saw the video, right? Just kind of pops out, pop. She falls. The crowd on the other side of the door, they go, oh gosh, somebody just got shot. There's a shooter here. And so everything sort of spilled into pandemonium. Then Techno continues. He says, continuing on, the DOJ maintains that the focus of the criminal investigation was to determine whether federal prosecutors could prove that they violated any laws. And they're focusing on the term willfully. Prosecutors would have to prove not only that the officer used force that was constitutionally unreasonable, but that they did so willfully. Then he goes through and says they concluded it revealed no evidence beyond a reasonable doubt that there was a willful violation of the law. Officer, it cannot be proved that he did not reasonably believe that he needed to do this in self-defense. So Techno says that the conclusion should be no surprise, not because of the law or the facts, but because of the people in charge of the Department of Justice. U.S. Capitol Police, like the Park Police, have always had a special relationship with the DOJ, one that includes preferential treatment. This case is no different. For starters, why? There are three basic elements to a prosecution under the U.S. Code. One, the defendant was acting under the color of law, willfully deprived a victim of a federally protected right. So what do we need to do there? And we're talking a lot about Chauvin and all of these other cases, Kim Potter and Dante Wright, and on and on. Excessive force is easy to establish. The Supreme Court has held that the government must introduce evidence that the action of the officer in shooting to kill Babbitt was excessive in relation to a legitimate government objective. Right? So what is a legitimate government objective? He says this is an objective standard. The force must be objectively unreasonable when viewed from the standpoint of a reasonable officer at the scene. Babbitt was unarmed. She was climbing through a window, not attacking anyone. She's shot and killed. This is easily excessive. Right now, the corollary there, the response to that is that she was in the Capitol building. These were senators. These were House of Representative members. These were people who were elected leaders of Congress. And so, people say that if you sort of are measuring the severity of the crime relative to the use of force, and so if you've got a lot of people sort of storming the Capitol building with threats of killing people inside the building, that's a big deal. But the converse to that is, well, wasn't everybody gone already by the time they got there? Didn't they evacuate everybody? So is the idea that he was protecting Congress people, is that legitimate if there's nobody in the building? Next up, we've got willfulness. We have serious doubts about the DOJ position that there was, quote, no evidence to establish a violation of the law. As an initial matter, the DOJ press release neglects to mention whether the officer used excessive force. Instead, they go right to willfulness. They don't even talk about excessive force. We believe this reveals their intent to soften the blow of the press release. As to willfulness, 18 U.S. Code says that when the defendant understands that he is unjustifiably invading a legally protected interest or acts in reckless disregard of the law, then willfulness applies. The defendant doesn't have to think in constitutional terms. The DOJ exaggerates, he says. At worst, it lies. About the willfulness burden, we doubt the DOJ could prove willfulness in this case. Couldn't even prove it. Couldn't prove willfulness. He thinks they could prove it. In fact, the DOJ brought Section 242 prosecutions with less egregious facts. As the DOJ has argued in other cases, the officer's prior training on the use of force could be viewed as evidence that his conduct was willful. Are we to think that the officer didn't have training on when force became excessive? In another case, the DOJ argued, Fourth Circuit Court of Appeals, that to establish willfulness, the jury was required to find that the defendant intended to use more than was reasonable under the circumstances. For example, force that violated the victim's well-established due rights as a pretrial detainee. What makes this Ashley Babbitt case different? The victim and the location. He says this case should have gone to the jury if this killing took place in Minnesota or Chicago. The results would have been different. Yeah. Why wouldn't it be? It's a double standard across the board. We've seen this ad nauseum with the Capitol Hill cases. They should have gotten bail. We're denied that. Looking like, well, actually, things might be looking up a little bit. We expect that people have a right to a speedy trial and due process and things of that nature. The government started by coming out and saying, we can't handle these extra 300 cases. So we need very long continuances. We're going to just continue everything out. bunch of these defense attorneys just sort of rolled over. Yeah, sure, continuance. We don't have to deal with this stuff for another 60 days. No problem. So they just continued all this stuff out. Meanwhile, the defendants who have been charged with crimes who are not being granted bail are just sitting in there rotting in custody while other people are out on bail because that was a political prosecution. The others are not. And so the question was, is there going to continue to be a double standard here? And we're starting to see maybe the government is going to have to hold closer to the original standard. If we're seeing Antifa and BLM people get diversion deals where they get no criminal record as long as they are law-abiding for a certain period of time, why is that same benefit not being provided to other defendants in similar situations for similar violations? Maybe it is. Maybe it's going to start trending that way. But, the Ashley Babbitt case is just another example of that double standard. We don't even get a grand jury investigation into it. It's just, they just decide, no, we reviewed it. Not going to happen. Thanks for playing. Let's go to questions. Let's deal with some questions. We've got Besimiento says, please don't compare Breonna Taylor's shooting with Ashley Babbitt case. The former officers dealt with armed resistance and shot fired at them. Babbitt was unarmed. Yeah, you're right. So the facts of those cases were accurate. Now, Kenneth Walker, Breonna Taylor's boyfriend, was armed, and he shot back at the police, rightfully so, because they were breaking into his house, shot one of the officers in the leg. And so there was an exchange of gunfire in that situation. Breonna Taylor, of course, was killed unrelated to that. But my point here has nothing to do with the victims of the crimes. It has everything to do with the cops and the standards that the cops are held to when they start doing things like firing their guns at people or towards people, like through apartment buildings. That's the question. Some cops just sort of don't get charged with crimes. Other cops do get charged with crimes for very similar conduct. And the question is why? The officers in Breonna Taylor's case didn't get charged. The officer in this case didn't get charged. So we have to distinguish between the two. Why is that? We have our next question comes from Hack Consulting. If we can't find out who killed Ashley Babbitt, why do we know who killed the ones that are making the news? Right? It's a double standard. If the state is going to have a strict rule to prevent us from knowing the facts with Ashley, they better hold on to every other case too. Yeah, that's a good point. Norovirus says, should anyone mention the conspiracy theory that is going around? There are multiple videos on YouTube and elsewhere that Babbitt was not actually killed. The entire thing was staged. I'm not sure what to believe at this point because there was no autopsy revealed. Really? There was no name released of the shooter. There's nothing released. However, likely she was shot. And from the fairness standpoint, it is horrible injustice that there is no investigation. Well, they did some, we read the investigation. You can see how much went into that. But, I don't know about that conspiracy theory. I don't know if that's, if there's any truth to that or not. She looked like she got shot and got killed to me. But it is interesting if there's no autopsy. I would guess that there is, but I don't know. Who knows anymore? It's hard to keep track of this stuff. Soul Under Siege says, why was use of force justified? She was the only person out of thousands that was killed. There were cops right behind her. He did not need to shoot. So yeah, there you go. Yeah. I mean, I think cops shoot often a little bit too soon. That may have been one of them. Jeremy Matrida said the officer that shot Babbitt should at least be tried. However, people working in the Capitol are never held accountable to the law. As the leaders of the free world, they should be the ones who set the standards. Yeah. Good to see you, Jeremy. We have HLB says, if willingness is so hard to prove, then why don't we use a more applicable word? So just change the word, right, to something that's easier to prove. I like that strategy. It's good legal strategy there. Good to see you, HLB. Thanks for joining in. And those questions all came over from watchingthewatchers.locals.com.